September 24, 2014, extreme mountaineer Sebastian Haag and Andrea Zambaldi died in an avalanche on Nepal Shishapangma. Both athletes were sponsored by Dynafit, promoting its mountaineering equipment. The German media outlet Spiegel Online reported live. The group tried to reach the summit despite an extremely high avalanche risk. Only a Sherpa pulled out of the climb. Personal ambition, cognitive biases, sponsor expectations, and media interest had created a powerful death trap. It snapped. This sad story opens a new research paper by Professor Horst Heidenmüller entitled Setting Up Dates with Death, the Law and Economics of Extreme Sports Sponsoring in a Comparative Perspective.
Thank you for inviting me.
The story we heard at the beginning, is this something that is increasingly more often in this sport?
Yeah, I think this incident that you've just described kicked off my interest in the whole project. And then, of course, I looked more in depth into the industry, and it's not an isolated event. Stories like this appear now quite frequently, and you read about extreme sports athletes dying or severely injuring themselves while practicing their sport with significant media presence at the same time.
So is there some necessary link between the definition of extreme sports and the risk of death?
Yeah, sure. I mean, when you start thinking about what to study, you have to come up with some kind of definition of the object of your study. So what is an extreme sport? And if you look at the literature, there are various different definitions out there. Some say, well, an extreme sport is everything that's not sort of a regular sport. It's kind of something that's just unusual. If you use that sort of definition, then there's no close link to death or serious injury when the sport is being practiced. However, I decided to use a more narrow definition of extreme sports that looks at those sports which carry the risk of an immediate or sudden death of the athlete when practicing the sport. And I did so in order to better understand the cognitive and other mechanisms that are involved in taking extreme risks, basically.
I see. So what strikes me as very interesting in your opening example is that the Sherpa, who wasn't sponsored by Dynafit, I suppose, in this case, he pulled out. So this is really something important to your paper, is it?
Yeah, I mean, it struck me as well. See, you've got these 6 mountaineers, and all of them are sort of professional, semi-professional mountaineers, all were sponsored. The only person apparently who wasn't sponsored in that setting was this Sherpa, and he had sensed the danger, as all the others had, but apparently not being under the same sort of pressure to achieve some extreme success by doing this. He said it's just too dangerous and I'm not going, right? So in a sense, this kind of Sherpa is a control group for the whole story that I'm exploring, whether it is sponsorships and the pressure created by sponsorships in the interaction with the media that forces athletes to do things that upon reflection they wouldn't do.
So I realize that this might be a slight overstatement, but if you were to summarize the main claim, is it really the case that sponsorship contracts force these athletes to take inefficient risks?
I think that the pressure on athletes to perform arises from a variety of sources. There is, of course, the personality of these athletes, who are, after all, outliers in a very clear sense with respect to our societal setup. They are persons who, by their very personality, are kind of prone to take extreme risks, and they love what they are doing. So There is this. Then there is the issue of the presence of the media, facilitating and publicizing their activities and promoting, maybe taking inappropriate risks under certain circumstances. And then there are the contracts and the design of these contracts that may, to a certain degree, incentivize athletes to do something that, upon reflection, they rather wouldn't do because of the specific incentive structures that are built into the contracts.
Well, it seems that in this context, one of the central parts of your argument is this cognitive biases that we have when we put ourselves into risks. And when I look into some studies that are not mentioned in the paper, it seems that social media, there is no conclusive data as to whether social media increase or decrease risk-taking with regards to young adults. Is this something that you also look at, or do you only look at the influence of the sponsoring contracts?
I'm primarily interested in the sponsoring contracts, but there is, of course, a link to social media because the compensation the athletes get usually is a two-tier type of compensation. They get a certain base compensation for what they're doing, and then there are bonuses. And these bonuses are tied to different events. And one of the events, these bonuses are tied to our appearances or likes on social media. Competition results is something else. So there is a link to social media appearance, basically. So the more popular an athlete, the more likes he or she gets, the higher the compensation, basically. So in this sense, the studies that you've just described come into the analysis. However, risk-taking is also facilitated simply by bonuses handed out for other things like social media appearances. So, for example, if a company says, if you participate in a particular competition and get a prize, we just double or triple your prize money, then that has nothing to do with social media performance. It just has to do with performance in a particular competition. And the athlete knows that if he or she wins, he or she gets a very high price. And that, of course, pushes the athlete. That's the assumption, I think, that was brought out in the analysis.
Okay, these are some very interesting facts about the mechanics of the sponsoring contracts. So how did you arrive at these results?
That was a key challenge from the very beginning, of course, because almost all of these contracts are not public. There are some firms, some sponsor firms who are listed, and one could think that as part of their fighting duties with the financial markets authorities, one could get an insight into some of these contracts, but these are very few. So most of these sponsor firms are not listed companies, and the contracts are, of course, private. So the idea was to somehow get hold of these contracts. Now, we wrote to firms, and I wrote to firms and trying to make contact and getting an information about their contracting practice, but the firms didn't want to talk about it, and of course they didn't want to reveal their contracts. So I needed to access athletes, and that proved to be more easy, of course, first because I have friends in the industry, athletes, whom I could talk to, and then there were many others who were willing to speak up. So I did a series of 40 interviews with extreme sports athletes over a period of 3 months in this summer.
So perhaps this will be of interest to our viewers. What was the most shocking information that you obtained by these interviews?
I think what surprised me and concerned me most, let's put it that way, was particular information regarding very young athletes. Because this is a trend in the industry that those athletes who get sponsored tend to get younger and younger. Some are minors still, 16, 17 years old. So firms approach them when they just sort of appear on the scene. And for these athletes to do something noticeable to get sponsored is very important, and it's difficult to get noticed because there's so many good athletes out there. So these very young athletes, quite unexperienced, they have to take pretty extreme risks or make or engage in sports that are even more extreme than the others in order to get noticed. And I think that's the group especially that society should be concerned about. those who are 16, 17, 18, 19, 20, 21 suffer the most from certain biases as compared to very experienced extreme sports athletes who are 30, 40, 50 years old, and are hooked up by the sponsors with incentive mechanisms that reward extreme risk-taking.
So would you say there is some regularity amongst sponsoring contracts across the globe, or did you see some differences?
No, we couldn't find much differences. So the basic structure of these arrangements, these sponsorships, is pretty similar. We had athletes based in North America, Canada, Australia, and Europe, and that's where most of the big sponsor companies are located. And the reports that we got on the structure of the contracts and the agreements are pretty similar. So there are no significant differences, which is probably due, this is a hypothesis, due to the fact that the whole industry competes globally, basically, on product markets and also on input markets. So it's no wonder that the contracting practices are pretty similar.
But then it's crossed my mind that one of the reasons might be that there are not individualized contracts. Is it the case, or?
These contracts, most of these contracts, almost all of them, are not individually negotiated. So most of the contracts that we see are boilerplate, basically. So standard form contracts that are just carried forward, basically. And we got quite good evidence for that. So, for example, athletes reported that there are still reward mechanisms in these contracts that that compensate athletes for example, a cover in a magazine that they get, a cover shoot in the magazine with some extreme sport feat that they accomplished. That was something that was quite important 10 or 15 years ago, but right now, given the development of social media, it has become, of course, less and less important. But it has been carried forward up until now, and the contracts haven't changed. So they are just carried forward, maybe without significant changes.
Now, let's turn to this idea of more efficient contracting practice. So in your paper, if I got it right, you argue that there is a room for improvement and the contracting practice could be more efficient if both parties paid more attention to their overlapping interests. Now, could you perhaps a bit explain what these overlapping interests are and how the parties might communicate better?
Right. So, being a scholar who's interested in negotiation theory, I looked at the practice, of course, with that lens. And one of the key insights in negotiation theory is that you should think hard about the interests of the parties and not the positions that they take in bargainings when you think about how to create value, how to increase the corporate surplus. So it became quite clear that there are a lot of common interests. So both sponsors and athletes have a very strong interest in safety, in making this sport exciting and safe. So increasing safety is good for both parties. And then there's also something else that's quite interesting, because sometimes you can create value by exploiting differences between the parties. Of course, the sponsors care about money. They don't want to make profit. But the key question is, what is the key driver for making profit? Is this more increasing revenues in this game, or is it more about keeping costs down? And it seems to be the case it's more about increasing revenues. It's not a cost game that sponsors pay. And athletes are not interested so much in money either. So most of them are doing what they're doing for the love of their sport. And they love the excitement. They want safety and they want security for themselves and family, but it's not so much a high compensation. Compensation is more a token of appreciation, basically. And if you take these two things together, that means basically that sponsors can do a lot of good things for athletes with relatively little money, which doesn't hurt them much. And the three areas where I identified rooms for improvement are this. First, sponsors could and should set up systems systematic counseling and coaching programs for athletes. Second, sponsors should think hard about the compensation structure, and especially the compensation structure which hands out bonuses that are tied to social media performance or to competition results. So maybe both parties would be better off when sponsors just paid a flat compensation, a base compensation, and don't hand out bonuses at all. Right? And there are other ways for improvement, especially establishing a comprehensive health, life, and disability insurance scheme. As I said, sponsors have an interest in keeping the sport safe and not having negative publicity. Athletes have a strong interest in safety and in the protection in case there's an injury or even death. In case of death, it's about their families. So by setting up an insurance mechanisms, both athletes and sponsors would benefit significantly. In fact, we learned during the interviews that athletes would be quite willing to give up some compensation in order to have comprehensive health, life and disability insurance, which currently they don't have, most of them at least.
Well, let me push a bit on this point. So, is it really the case that sponsors are interested in the athlete's safety? Because I could imagine that those young firms that want to enter the market, so they would take any publicity, not only the positive publicity. So given the lack of access that you had to the sponsors and to obtain their views, do you think this is really the case?
They are, and there is certain evidence that supports this view. So when a couple of years ago, for example, a well-known ice climber died doing a practice climb, Red Bull at the time was sponsoring that ice climb, but pulled out of sponsoring ice climbing for a certain period. And also other firms like Cliff Bar have stopped sponsoring athletes who are engaged in free solo climbing and in certain extreme sports. So sponsors are concerned about their reputation and about negative publicity. That's what you can derive from this. So they apparently have an interest that no serious accidents or death happens that are associated with their brand.
Good. Now, let's turn to the last section of your paper where you propose some legal solutions and where you do the actual comparative legal analysis, which I found extremely interesting. One thing I wanted to ask you about is you propose a specific standard of care for the sponsors. Could you perhaps explain this a bit to me?
Right. So the question is, what should or might the courts do in case the contracting practice doesn't evolve in the direction that I'm suggesting? So the parties don't take up the possibilities to improve on the contracting practice that I've been suggesting. Is there a case to be made for courts under certain circumstances to step in and override the contracts? So one has to think about the kind of scenario that might evolve that could give rise for the courts to consider intervening with mandatory rules. And one of the scenarios is, of course, a serious accident or death of an athlete, and the athlete and or the heirs of the athlete contemplating a negligence action against the sponsor if allegedly some kind of fault on the side of the sponsor, some kind of negligence contributed to the accident that then led to the death or serious injury of the athlete. And within that framework of negligence, you can think about, so what would or should the standard of care be that we hold the sponsor to in a setting involving an extreme sport event, and might the sponsor have violated that standard of care? And here the analysis that I have conducted with respect to how the contracting practice might get improved comes in through the back door, in a sense. Mm-hmm. When you think about the standard of care, the sponsor should be held to.
So do you think there are some specific contractual provisions that should be implemented in this area?
I think the most straightforward sort of change that could be and should be initiated by the courts is when they see a case like this and maybe have an athlete who's very young and inexperienced, and they consider whether the sponsor is liable under a negligence heading, they would have to think hard about the kind of precautions that the sponsor has taken to avert this from happening, and the counseling and coaching and training duties that I have submitted would increase the contracting surplus. They could come in this analysis, especially vis-a-vis young and inexperienced athletes. So if a sponsor doesn't have anything of that kind, then the court might be more inclined to say, okay, so this is negligence, this is unprofessional, the sponsor should have done something like this. And secondly, that's kind of more controversial. One can also contemplate whether a court might say, okay, now I see this contract, and this contract is not just with a very young athlete who's inexperienced, but the contract also doesn't have some kind of base compensation. It's just a bonus-based contract where the athlete is rewarded for some kind of extreme risk that he or she takes and the media coverage that gets. So the sponsor here kind of pushes the athletes literally over the brink, basically, with that high-powered incentives. And I consider this to be also violating what a professional sponsor would do. A professional sponsor shouldn't incentivize, especially young and inexperienced athletes, with these kinds of contractual provisions. So that's probably more controversial, but I can conceive of this happening. And then there is, if I may add to that, then there's another issue, namely the degree to which the sponsor was involved in setting up the event, basically, right? So this is one thing, for example, if a sponsor just chooses a location for an extreme free ride, skiing activity that's then covered by a video, or whether the sponsor designs a competition course for extreme mountain biking, for example. Of course, in the latter case, when the sponsor builds a course, the sponsor will be held to different standards of care than the sponsor who just says, well, we're going to shoot this in this particular area, for example.
I see, and I think this perfectly illustrates also another concern of your paper, and that is employment law implications.
Right.
Because the sponsors quite often exercise a higher level of control. So is employment law something that should also be considered? Yeah.
So I looked at this because it struck me right from the start as kind of almost like a puzzle that there are activities which are pretty similar to those activities these sports athletes engage in, where clearly those who engage in these other activities are protected by employment law. Just think about somebody who's working for companies cleaning high-rise buildings, right? And on the other hand, you have a free solo climber who climbs faces without a rope. And of course, in the first case, this person is an employee of that company, and there are extremely sophisticated safety precautions, of course, to make sure that that employee isn't hurt when practicing his or her activity as an employee. And that raises the question, well, is it really the case that these extreme sports athletes are all independent contractors? Or what is their relationship to the sponsors? And what's the degree of control? And what's the degree of dependency? And might a threshold at some point be crossed where one has to appropriately say, well, they are rather employees? Now, there are two things I think that are important to keep in mind here. The one thing is kind of the problematic dichotomy, because being an employee brings, or would bring for the independent contractors, or for the athletes, I'm sorry, some benefits, but it would also, of course, be not so good from other perspectives. So it would limit their freedom. They would then formally be subject to control by the sponsor. It would also maybe have certain negative tax consequences for them. So it's kind of a two-sided sword, basically. It's not an unqualified good. And then the other issue is the facts of the situation. And what are jurisdictions using as a test to determine whether somebody's an employee or an independent contractor. And I think the interviews brought out that the economic dependency by many athletes is pretty high. But the degree of control that the sponsor exercises is probably not significant enough to say that they fall into this latter category. However, the analysis has interesting repercussions, I think, with respect to the analysis that's looking at the standard of care, because I think it is pretty convincing to suggest that the higher the degree of control that the sponsor exercises over an athlete, the higher the economic dependency of the athlete on that particular sponsor, the higher the standard of care that the sponsor faces with respect to the athlete exercising or practicing his or her sport. So courts might, when engaged in a negligence analysis, take this into account, despite the fact that the athlete is not a worker or an employee of that particular sponsor.
And so is this something of a real concern amongst the athletes? Do they want to be employed, or do they even discuss it?
We asked this question, we discussed it with them. I think it would be fair to say that most athletes don't really want employee status, right? And it's clearly was easy to understand why. I mean, they are engaging in extreme sports, and they're taking extreme risks. That's what they love, that's what they do. And freedom, of course, is essential to their lifestyle. Okay, it's something that they cherish. They want to choose the projects that they want to pursue, etc., etc. And conceiving themselves of employees of a sponsor is not really what they want. So they don't want to be employees. At the same time, what they clearly all have said is they want to see certain changes in the contracting practice. They want more protection, they want more safety, they want more stability, and they also feel undercompensated, most of them. They want a higher compensation, right? So they are very much pushing for a change in the contracting practice. However, they are reluctant to push into the direction of being conceived of as employees or workers.
First, you must be aware that this paper will trigger a debate across the sponsors and across the athletes as well. Is there something in particular that you want to be picked up by?
I think the main objective of this paper is to start a discussion, to start a debate, to get sponsors think about these issues, and to get a discussion going between sponsors in particular and athletes on the other hand, and also the media, because the media plays a key role in facilitating these risk-taking activities. And if I achieve that objective, I think I've achieved the main purpose of this study, of this scientific analysis, because it is by virtue of this debate, by virtue of this discussion then, that the parties will reflect upon the contracting practice and we'll see whether there are reasons to change something and to move the practice in a different direction. So that's what I anticipate and hope is going to happen.
And from your own perspective, is there some next steps that you want to take, some next research that you want to do in this regard, or is this a finished project?
No, when I was writing this paper, I, of course, came upon many different issues or problems in the field that relate to the design of the contracts, that relate to the mechanisms of risk-taking, the psychological, cognitive mechanisms of risk-taking, that relate to sponsors, multiple sponsors engaging into a sponsorship agreement. This is sort of a game theoretic problem. So there are many, many issues within this study that I've conducted, this initial studies, that are worthy to be explored further. And what I'm contemplating basically is to do a conference on the sponsoring of extreme sports athletes. and invite athletes, sponsors, media representatives, and scholars to look more specifically at the issues that I have touched upon, some of them only touched upon in the paper.
Excellent. Well, it looks like we have something to look forward to. Perhaps by way of conclusion, Arst, could you summarize the main message of your paper in 1 or 2 sentences?
I think the key outcome of this study is that the sponsorship practice with respect to extreme sports currently is unbalanced in the sense that athletes are disadvantaged and they're incentivized to take inappropriate risks that upon reflection they wouldn't want to take. And I hope that by bringing to light the details of the existing practice, I engage everybody in the industry in a debate to improve the sponsorship practice for the benefits of athletes, sponsors, and society as a whole.
Professor Horst Eidelmeyer, Freshfields Professor of Commercial Law, University of Oxford.
Thank you.